Hello everyone. So today we are going to start with the fundamental rights. Okay. So fundamental rights, what do you understand by them? So as you know that they are the most fundamental rules or guarantees that our constitution provides. So yesterday we saw all the chain of the events that had happened. So firstly the demand for the constituent assembly. Then we saw the salient features of the constitution. Okay. After that, we saw the preamble, after which we saw union and its territories, part 1. Then we saw citizenship, part 2. Right. So today we are going to talk about the fundamental rights. So the fundamental rights are not like a gift from the state, they are limitations imposed on the state. So this is very important to understand that they are limitations. You must have seen these kind of questions arising a lot of times. Limited government, limitations on the state, arbitrary limitations, all of these things. So fundamental rights basically do that. Okay, so they are so that they ensure that the state does not become tyrannical and the citizens are protected against the arbitrary actions. Okay, so if a constitution begins with power, so if any suppose if any government is given a lot of power, there are chances that it can become authoritarian. Okay, but if it begins with rights, if there are some rights that are defined and there are some rights that are bestowed upon the citizens, so then it becomes democratic. Okay, so where do you see the fundamental rights? They are in the part 3, articles 12 to 35 of the constitution. Okay, and they are enforceable by the courts, and that's why they are considered justiciable. So if there is a case wherein your fundamental rights have been breached, so you can go to the courts. This is what you mean by justiciable. Okay, and they are for promoting the ideal of political democracy. You have to tell me, and we have also discussed this yesterday, what promotes the social and economic democracy. Okay, so we saw where they are. They are in the part 3 of the constitution, and they are also called as the Magna Carta of the Indian Constitution. So how many fundamental rights are there? There are 6 types of fundamental rights. The right to equality from article 14 to 18. Then we have the right to freedom from article 19 to 22. Then we have right against exploitation, article 23 and 24. Then we have right to freedom of religion, 25 to 28. We have cultural and educational rights, which is 29 and 30. And finally, we have the right to constitutional remedies. So the if any of these of your rights have been violated, okay, so to get a solution is also a fundamental right. To get a remedy for that violation is also a fundamental right in itself, which is article 32. Okay, so can they be limited or taken away? Are these fundamental rights, are they absolute in nature? Suppose once you've got a right of equality, so is it that you'll be considered equal in all circumstances, no matter anything, doesn't matter what the procedure is established by, or what the law is, it doesn't matter? No, fundamental rights are not absolute. Okay, rights can be restricted during emergencies, and parliament can also amend them. You can't say that this is your fundamental right and you cannot amend them, but you can. The parliaments can amend them, but there is one limitation to it. The limitation is the basic structure. It cannot be destroyed. As per the Keswananda Bharti case, the landmark judgment that came up with the doctrine of basic structure says that you can do the amendments. You can amend the fundamental rights, but the amendment cannot destroy the core of the constitution, the basic structure of the constitution. Okay, the basic structure, has it been defined? No, it has not been defined. It sets a precedent every time a court of law, the Supreme Court, when it gives a judgment, it sets a precedent, but it is not defined anywhere. Okay, so now we will deal with the articles. So article 12, what is the article 12? The constitution doesn't care what you call yourself. Okay, if you exercise public power, you are the state. Okay, so article 12 defines a state. Okay, so it defines who is considered a state and who can be held accountable. Okay, so if you are supreme enough to make some changes to which will cause an impact on the lives of people, that means you are so powerful, so you have to be held accountable. Okay, and for that accountability, the constitution has defined what you are. So you are a state, and that's why, because you are so immensely powerful, that's why you have some limitations. Okay, so you have some accountability for that. Okay, so fundamental rights do not depend on labels, they depend on control. Okay, so you cannot arbitrarily say tomorrow, for example, you come and say that people from this caste are not allowed to enter this. You cannot do that. Okay, what about Article 13? Article 13 makes it clear that laws violating fundamental rights are void, ensuring the supremacy of the Constitution. ठीक है? So we saw Article 12 is definition of state. So what comes under that? What all things are under the state? So we see the executive and legislative organs of the union government, executive and legislative organs of the state government. Okay. Also all local authorities, that is municipalities, panchayats, district boards, improvement trust, and all other authorities, जैसे statutory or non-statutory authorities like LIC, ONGC, SAIL, okay, Coal India, all these things come under the definition of state. Now a question for you guys: does judiciary come under the definition of state? Does it come under the article 12? Okay, you have to find this out and tell me in the comments section. Next article is article 13, laws that are inconsistent with fundamental rights. Okay, so Article 13 declares that all laws that are inconsistent or in derogation of any of the fundamental rights shall be void. So this article provides for the doctrine of judicial review. We saw this yesterday a little bit. Okay, judicial review means what? The courts can review the law made by the parliament. Okay, so this is a system of checks and balances, right? So what does this article say? That any law that has been inconsistent or in derogation with any of the fundamental right will be void. Okay, so here you saw that the constitution has defined state for you. Okay, here the constitution has defined law. Okay, so what is a law? Permanent laws enacted by center and state, acts. Okay, temporary ordinance by president. statutory instruments of delegated legislation. Okay, just the executive legislation like order, then regulations, rules, anything that has a state backing is law. A question for you is a constitutional amendment, is that a law? So this was a question for a long period of time. Then the landmark judgment, the Keswananda Bharti case, said that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure. Okay, and hence can be declared as void. So constitutional amendment is also a law. Okay, so we will see the articles verbatim. Article 12 is definition of the state. Okay, so what all it includes? It includes executive and legislative organs plus other authorities, जैसे कि local governments, जैसे municipalities, panchayats, district boards, and other authorities, जैसे statutory, non-statutory, ONGC, LIC, SAIL. Okay, then we have Article 13, laws that are inconsistent or in derogation with the fundamental rights. So we saw anything that is inconsistent with the provisions of the Part 3 shall be to an extent of that inconsistency be void. Okay, so this provides for the doctrine of judicial review. Okay, the state shall not make any law which takes away or abridges the state shall not make any laws that which takes away or abridges the rights conferred by this part. Okay, so the states can't make laws that violate the fundamental rights. Okay, then a law includes ordinance, order, bylaw, rule, regulation, notification, custom, yes, sub everything. Okay, laws in force matlab laws passed or made by the legislature before the commencement of the constitution. Okay, so this also talks about before the commencement. Before the commencement, as in when? Before, sorry, 26th Jan 1950. So, what about the laws that were there before this commencement? Okay, so before the laws that were in force, which were made before the commencement and were not previously repealed, okay, so those laws can also be repealed. Okay, then what about the constitutional amendments? So, constitution amendments under Article 368. So, this means that the parliament can amend the fundamental right as long as the basic structure is intact. Okay, so the question was there that whether the fundamental rights can be amended or not. So, this particular article, the part of this article answers this question that yes, you can amend, but the basic structure should be intact. Okay. So what do you mean by this? When you say the basic structure should be intact, it means that the amending power is limited. Okay, and when you say the amending power is limited, it is because the sovereignty belongs to the people and not the parliament. So we don't have a completely sovereign parliament. We talked about this yesterday. Okay, now we will begin with the fundamental rights properly. Right to equality. Okay, so equality, what do you understand by equality? Do you mean equality is sameness, everything is same, Or is it fairness? You should do what is fair for everyone. Okay, do you think you should do same for everyone, or do you think you should do something that is fair? Okay, so equality is fairness, it is not sameness. Okay, so the law, the article says that, articles from 14 to 18, these are the right to equality. So these rights say that the equality before law and equal protection regardless of caste, religion, gender or background. So it promotes fairness and prevents discrimination, and it ensures equal access to opportunities in a democratic society. So the first article now, Article 14. Article 14 talks about the equality before law and equal protection of laws. Okay. So what does the article state? The state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. What do you see here? The state. Okay, then you see any person, equality before law or the equal protection of laws within the territory of India. So territory of India, we saw yesterday what it means. Okay, the state shall not deny. So the government or the thing in power will not deny to any person. Does it say just citizen? No, person. Okay, it means citizens plus foreigners also. Okay, now here you see that there are two concepts. Concept one is the equality before law, and the second concept is the equal protection of laws. Okay, equality before law is of British origin, and it is a negative concept. What do you understand by that? Negative matlab, it is not bad. Okay, it only means that there are some limitations. Negative means no special privileges, so there is a limitation for privilege. Then equal subjection of all persons to ordinary laws, so which is basically no privilege, and no one is above the law. Okay, so these are the limitations, so there is some negative, there is a bar kept on them. Okay, the Court has declared this principle a basic structure of the constitution. ठीक है. One note for you is that in the UK, the courts define the rights, and in India, the constitution is the source of rights. Okay, the next we have the equal protection of laws, which is of the American origin and is a positive concept. So you'll see the difference now. What do you understand by this? It means that equal treatment of individuals in similar conditions. We discussed this yesterday also, like should be treated alike. Okay, equal application on the same laws and no arbitrary discrimination. Okay, like should be treated alike. ये है उसका मतलब. Okay, so two concepts. One is equality before law, one is equal protection of law. Okay, this is a British concept, this is an American concept. Okay, this focuses on no privilege, this focuses on fairness in application. Okay, do you think the rule of equality is absolute? No. Fundamental rights are basically not absolute. So, certain individuals enjoy special privileges under the constitution and international law. So, who are these people? Presidents and governors. Okay, MPs and MLAs, foreign diplomats. Presidents and governors, immunity from legal proceedings during their time, during their tenure. And MPs and MLAs, protection for statements made in the House. Okay, Rajya Sabha, Lok Sabha, the state legislative assembly. So whatever they say in these houses, they are protected from that. Okay, then the foreign diplomats, they have immunity under the international conventions. Okay, now we see the article 15. Okay, so the Article 15 ensures that no citizen shall face discrimination by the state on the grounds only of religion, caste, religion, race, caste, sex, or place of birth. Okay, so you have some keywords here. No citizen. Does it say no person? No, it says citizen. So this right is only for citizen. Okay, shall face discrimination. Okay, so no citizen shall face discrimination by the state on the grounds only. Sorry, only of religion, race, caste, sex, or place of birth. So there will be no discrimination only on these parameters. So is discrimination allowed in some other parameters? Yes, but a positive kind of discrimination. Okay, so meaning and scope is that the use of word only implies that discrimination is prohibited only if based exclusively on these grounds. Okay, the grounds that we talked about. This means differential treatment is not unconstitutional if based on valid considerations, just say residence, age, profession. Okay, you have some special laws for children, for example. Can you say, can an adult come and say, no, this is against my equality? How is a child treated differently? Yes, because the child deserves a differential treatment. Okay, and no citizen shall be denied access to public spaces like shops, restaurants, tanks, wells, roads, etc., if they are maintained wholly or partly by state funds. ठीक है? So this, the part 2 of the 15th. See, here you have. Okay, Article 15, prohibition of discrimination on grounds of whatever. Okay, so 15.1 says no discrimination based on certain uh, grounds. Then 15.2 talks about equal access to public spaces. If it is state funded, it is for all. Okay, so suppose if someone has a private pool, okay, swimming pool, can someone go and say, no, this is for my equality, you are having it, so even I can have it? No, it is their private pool. Okay, but if it is a state funded pool, then of course everyone is allowed there. Okay, then 15.3, 15.3 has permissible exceptions. Okay, so 15.1 and 52 15.2 talks about you cannot discriminate, but 15.3 says ki, yeah, that you can discriminate, but if you have based those discriminations on some valid grounds. So that is your positive discrimination. Okay, just say women and children, protective and welfare based provisions. Okay, some schemes are developed for them. Then socially and educationally backward classes, just say you have reservation in educational institutions. Then scheduled castes and scheduled tribes, special protections and benefits. Economically weaker section, EWS, via the 103rd amendment, so up to 10% reservation in education and public employment. So this is how you are making that differential, you are giving the differential treatment. You cannot come and say, no, this is uh abridging my fundamental right. No, but it is for the betterment of someone who is already behind you. Okay, so in this case it is okay. So when you talk about reservation, now reservation is not an exception to equality. Okay, it is not ki equality is there, which talks about no discrimination, and reservation is there as an exception. It is a method for achieving equality. Okay, by reservation, you are enabling some people who have been worse off over the years, over centuries, to at least come in line with the people who have been better off. Okay, so formal equality is what the constitution begins with, and substantive equality is what it strives towards. So, formally, we want everyone to be equal, but substantively, we have to take some actions which will ensure the equality. Okay, so this is your Article 15. I have given you verbatim because a lot of time questions have been asked from the article itself. So, to make sure that you don't miss on anything, I've given this. Then we have Article 16, equality of opportunity in public employment. So Article 16 guarantees that every citizen shall have equal opportunity in matters related to public employment or appointment to any office under the state. So what are the keywords here? Every citizen, equal opportunity in public employment or appointment to any office under the state. Okay, so here again this is for citizens only. It doesn't say persons. Okay, so what is the core principle here? It is again no discrimination in public jobs on grounds only of religion, race, caste, sex, descent, place of birth, or residence. Okay, but again, there are some permissible provisions, exceptions. जैसे 16(3) says that Parliament can allow residence as a condition for certain jobs in state, UT, or local body. Okay, so the people who are the resident people of that particular place will have some kind of reservation. Then 16(4) talks about reservation in favor of backward classes who are not adequately represented in state services. Then 16(4)(a) talks about the reservation in promotions for SCs and STs. Then 16(6) it talks about the 103rd constitutional amendment, which is the EWS quota. Okay, so these are some kind of exceptions to the Article 16. So one question for you. Who can make the residence as a condition for certain jobs? The Parliament. Make sure that you understand. Even if it is a state, even if it is a state job, state, UT, local body, only the Parliament can make the laws and not the concerned state legislative assembly. Okay. Now we move to the abolition of untouchability, Article 17. So Article 17 abolishes untouchability and forbids its practice in any form. So what do you understand by this? It declares any disability arising out of untouchability as an offense punishable by law. So for this, it was enforced by the Protection of Civil Rights Act, which was enacted to enforce the Article 17. Okay. The term untouchability, has it been defined in the Constitution? No, it is not defined in the Constitution or in the Act. Okay, because if you define it, maybe it becomes very constructive and it becomes very in the bracket. Okay, if someone does something out of it, which might also lead to some kind of untouchability, but you can say, no, this is not there in the law or in the Constitution. So it is not untouchability. No, so that's why they've kept it a little open, because you don't really know what people face. Okay, but it is understood to mean social exclusion based on caste. So that is untouchability. Okay, on a broader sense, it means social exclusion. Okay, why is this article unique? Because all this time you saw that nowhere it has been talking about an offense. Okay, it was not talking about criminalizing something. If you are doing such thing, it didn't mean it was criminalized, but this is an offense which is punishable by the court. So the untouchability criminalizes the social practice. Okay, this article of untouchability. Okay, and the Supreme Court has clarified that this right is enforceable even against private individuals and not just the state. So that's why this article is very unique, because here everywhere you saw, okay, state. Here also you must have seen. Where did it go? State. State. ठीक है. But untouchability is enforceable even against private individuals and not just the state. Okay, now we move on to the next article, abolition of titles. Okay, so why was this needed? Because during the British rule, a lot of people had got titles from them. Zamindari, Inamdari, okay, all of these titles were there. And they were causing an aristocratic distinctions in a democratic society. ओके, सो यू कुड सी दैट समवन हायरार्की दिखती थी उसमें कि हाँ ये जमींदार है, ये इनामदार है, तो ये हमसे बड़ा है. So to ensure equality and prevent these aristocratic distinctions in a democratic society, this abolition of titles article was made. Okay, so what are the contents of this article? The state cannot confer any titles except for military or academic distinctions on any person, whether citizen or foreigner. ठीक है, and no foreign titles for citizens. So Indian citizens are also prohibited from accepting titles from any foreign state. So Indian state, the state as in Indian government, that also cannot confer any titles. Plus Indian citizens are also not allowed to have titles from any foreign state. Okay, and suppose there are some foreigners in Indian service, a foreigner working under the Indian state cannot accept a foreign title without the president's consent. Okay, so you need the president's consent before a foreigner who is working in Indian services gets a title from the foreign state. Okay, and no gifts or position from foreign states. Citizens and foreigners holding any office of profit or trust under the Indian state cannot accept presents, salaries, and offices or positions from the foreign states without presidential approval. Okay, now here one big question came, whether the awards that are given, okay, like Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri, are these titles? So the Supreme Court upheld the constitutional validity of the national awards and said that these awards do not carry titles, so they are not titles under Article 19. Okay, and they should not be used as honorific prefixes. Okay, so here you see that you can use titles that are military and academic in nature. So suppose someone is a lawyer. Okay, so they might put advocate in front of their name. Okay, advocate Ramesh, for example. Okay, someone is a doctor, then they put Dr. Suchita. Okay, they do that. But suppose someone gets an award for Padma Shri, so you cannot put Padma Shri Satish, for example. You cannot do that. Okay, this is not allowed. But if Satish is a colonel in the military, so you can put Colonel Satish. That is allowed. Okay, so these cannot be used as honorific prefixes because they are not titles. Okay, now we will do the right to freedom, which is from, so we are done with the right to equality. Okay, so now we are doing the right to freedom from Article 19 to 22. The right to freedom guarantees the essential liberties that form the core of democratic life. Okay, it empowers individuals to express themselves, move freely, and live with dignity while ensuring protection from arbitrary arrest and detention. Okay, so कहाँ से कहाँ तक है? 19 से 22 तक है. Okay, so they balance the individual liberty with reasonable restrictions, so they are not absolute, there are some restrictions in the interest of public order and national security. So सबसे पहले we have the Article 19. Okay, so protection of certain rights regarding freedom, so freedom rights these are called. So Article 19 guarantees 6 fundamental freedoms to citizens of India. Okay, so what are the Six freedoms under Article 19(1) A. Freedom of speech and expression, right to express one's views freely. Okay. Then we have the freedom to assemble peaceably and without arms. So right to protest or hold meetings but in peace. Okay. Then you have the freedom to form associations or unions, right to join or create organizations or unions. Okay. Freedom to move freely throughout India. Freedom to reside and settle in any part of the country. And freedom to practice any profession or carry on any occupation, trade, or business. Okay. So the clause F. So you see after E there is directly G. So clause F, which was the right to acquire, hold, and dispose of property, was deleted by the 44th Amendment of 1978. Okay. So these rights are not absolute, like I said. They are subjected to reasonable restrictions. So Article 19 2 allows the state to impose these restrictions on freedom of speech and expression in the interest of sovereignty, security, public order, morality, defamation, and other specified grounds. Okay, so reasonable restrictions is in the clause 2 to 6. So, Article 19, clause 1, A to G had the freedom, but उसके लिए जो भी restrictions है are in the Article 19, clause 2 to 2 through 6. Okay, speech and expression के लिए क्या क्या है I discussed here. Okay, assembly के लिए sovereignty, integrity of India, public order. Association के लिए sovereignty and integrity of India, public order and morality. Movement के लिए general public interest, protection of scheduled tribes. Residence के लिए again the same, general public interest and protection of scheduled tribes. Profession and trade के लिए general public interest, technical qualifications, state monopoly in businesses. तो इसका एग्जाम्पल क्या है? सपोज a lawyer says that I want to become a doctor now. Okay, he has done LLB. He is a graduate and he has learnt the law. But now he's saying that for his profession, for his work, for a career, he wants to become a doctor. So that is not allowed, right? So there are some technical qualifications that are needed to perform that kind of profession. So an engineer will do some only he is allowed to do the engineering stuff, or a doctor is allowed to do the health stuff. Okay? And state monopoly in business. Tomorrow someone cannot say that I want to open my railways. Okay, because we have state monopoly there. So that is restriction. Okay, but there are some special provisions under Article 19(6). So a state can prescribe qualification for professions, like I said, example lawyer, doctor, and state can run trade uh, industries exclusively, barring private entries, जैसे railways. ठीक है, so this is all about your Article 19. Then we talk about the Article 20, protection in respect of conviction for offenses. So Article 20 provides safeguards to individuals accused of crimes, okay, ensuring they are protected from arbitrary unfair punishment. It applies to citizens, foreigners, and even legal entities like companies. Okay, तो ये सभी के लिए है. So there are three important parameters here. No ex post facto law. Okay, what do you understand by this? A person cannot be convicted for an act that was not a crime when it was committed. Okay, I'll give you an example. Okay, let's say for example, today, not today, let's imagine yesterday. Okay, yesterday, theft was not a crime. Okay, chori was not a crime yesterday. Okay, but today the government made a law saying that yes, chori is a crime now. So जो कल जिसने चोरी किए है उसको आज हम अरेस्ट नहीं कर सकते सेइंग दैट टुडे आज तो वो क्राइम है. नहीं, बट जब उसने किया था इट वाज नॉट अ क्राइम. Okay, so the person cannot be convicted for an act that was not a crime when it was committed. Okay, and a person cannot be punished more severely than what the law allowed at the time of the offense. Okay, again वही एग्जांपल लेते हैं. सो yesterday theft crime था, let's assume. Okay, it was a crime. Theft was a crime, but उसका punishment was suppose 10 days in jail. Okay, this is only an example. But today new law came, it said 1 year in jail. Okay, so हम ये नहीं कह सकते कि हाँ आज because there is 1 year so you have to do 1 year in jail. No, because that person during the commission of the crime the punishment was whatever this was allowed, 10 days was allowed, so he will serve the 10 days only. Now very important, now ये जो भी है this applies only to criminal laws and not civil or tax laws. Okay, suppose सिविल लॉज और टैक्स लॉज के लिए आज कोई रूल बनता है सो दैट कैन बी अप्लाइड for the previous things that were done but not for criminal things. Okay, the second part is no double jeopardy. What do you understand by double jeopardy? A person shall be prosecuted and punished. No person shall be prosecuted and punished for the same offense twice. दो बार for the same offense he cannot be punished and prosecuted. Now this applies only in judicial proceedings again and not in administrative or departmental actions. ठीक है. Then we have the no self incrimination under article 20 clause 3. So an accused cannot be forced to testify against oneself. Okay, and this protects both oral and documentary evidence, but this does not cover compulsory production of physical evidence and material objects, thumb impressions, handwriting samples, blood tests, and this again applies only to criminal proceedings and not civil cases. Okay, so three important things: no post facto law, no double jeopardy, and no self incrimination. Okay, so here you see 21 is no ex post facto law, 22 is no double jeopardy, and 23 is no self incrimination. Okay, now we move on to the most powerful fundamental right, which is the Article 21. So the text says that no person shall be deprived of his life or personal liberty except according to procedure established by law. So Article 21, it just began as a procedural clause, but it evolved into a foundation of human dignity. It is one of the most expansively interpreted and judicially enriched provisions of the Constitution. Okay, and it applies both. Person बोला है तो it applies to both citizens and non-citizens alike. Okay, and has become the foundation of many derived rights in India. Okay, so we'll see the key judicial interpretations which have derived it into the most expansive right. First one is A.K. Gopalan case. So A.K. Gopalan case gave a very narrow interpretation. What it said was Article 21 का जो भी protection है was held only against arbitrary executive action and not legislative action. Okay, so procedure established by law meant any law passed by the legislature, even if unfair, was okay, according to A.K. Gopalan. Okay, so suppose a legislation, a law is made tomorrow, okay, saying that people with brown hair example. Okay, people with brown hair are not allowed in this country. Okay, this seems very wrong, correct? But since it is passed by the legislature, which becomes a procedure established by law, so A.K. Gopalan said कि हाँ ठीक है, क्योंकि it is a law, so yes, you have to abide by it. Okay, so it gave arbitrary, I mean, it gave protection only against the arbitrary executive action and not against arbitrary legislature. ठीक है. Then came the Maneka Gandhi case, which changed the course of Article 21. So it gave a wider interpretation, which overruled Gopalan, of course, because it was narrower, and held that procedure must be just, fair, and reasonable, thus introducing the American concept of due process of law. Okay, so it expanded the scope of personal liberty and opened the door for new fundamental rights. Okay, so what do you understand by due process of law? It means even the law that is made, even the legislation that is made cannot be arbitrary. Okay, it should be based, just, fair, and reasonable. Just, fair, and reasonable. Do you think the law that I talked about, from tomorrow brown colored hair is not allowed? It's not reasonable, right? So it becomes arbitrary and hence it can be void. ठीक है? So you have a very long list of expanded meaning of the right to life. You can go through it because a lot of times questions have been asked. So important ones is right to privacy, case Puttaswamy case. Okay, right to marry recognized under Article 21, right to livelihood, clean environment, education, health, everything. They are also recognized through various judgments over time. Okay, right to life, and same way the right to die also. Okay, what about this? This is a question for you. You have to find it out. Now let's move to the right. Now, Article 21A, right to education. So, Article 21A says that the state shall provide free and compulsory education to all children aged 6 to 14 years in such manner as the state may by law determine. Okay. So, this Article 21A was inserted by the 86th Constitutional Amendment Act of 2002. Okay. And finally, it came into effect on April 1, 2010 via the Right to Education Act 2009. ठीक है, पहले this was just, so you'll see here now constitutional integration by the 86th Constitutional Amendment Act was, it changed, एक तो it added Article 21A, then it changed Article 45. Okay, so it's in Article 21A it says makes education a justiciable right for children age 6 to 14. Okay, and change the DPSP Article 45. So it recast to promote early childhood care, education, and education below age 6. So 6 to 14 tak it was made a fundamental right. Less than 6 it was made a DPSP, that you should give the child the care and education. Okay, then 51A and subclause K, this was added. It mandates parents and guardians to provide education to their children aged 6 to 14. So this is the duty of the citizens. This is the right of the children. Okay, with the states. So states should make it justiciable for children to get education for this age group. Then DPSP below 6 also the state should give some kind of care, and the fundamental duty of the parents and guardians is to provide education to their children aged 6 to 14. ठीक है. So this was added by the 86th Constitutional Amendment Act of 2002. Okay. Now we will go with the protection against arrest and detention, Article 22. Okay. So Article 22 provides safeguards for individuals who are arrested or detained, whether punitive or preventative grounds. Okay. So there are two kinds of detention. You have punitive detention and when you have preventive detention. Okay. Punitive means what? Detention after a crime is committed, followed by a trial and then a conviction. Suppose someone has um, committed a murder. ठीक है. मर्डर कमिट किया है, उसका ट्रायल होता है. ट्रायल एज इन उसको कोर्ट में सुनवाई, करेक्ट, कोर्ट में पेश किया जाता है. द एंटायर ट्रायल इज डन एंड द कोर्ट हैज कन्विक्टेड दैट पर्सन ऑफ मर्डर. द कोर्ट हैज डिसाइडेड कि हाँ दिस पर्सन हैज वो सब सबूत एंड सब एविडेंसेस को मद्देनजर रखते हुए इट इज बिन कन्विक्टेड. फिर उसको जो जेल होता है, फिर उसको जो पनिशमेंट मिलता है, दैट इज प्यूनिटिव डिटेंशन. ओके. बट प्रिवेंटिव डिटेंशन इज डिटेंशन विदाउट अ ट्रायल टू प्रिवेंट अ पर्सन फ्रॉम कमिटिंग अ पॉसिबल ऑफेंस इन फ्यूचर. सो मे बी उसने वो कमिट किया भी नहीं हो क्राइम, बट देयर इज a chance that he or she might commit the crime in future. तो उस वो commit करने से पहले ही this person is kept in detention. So that is detention without trial. तो यहाँ पे you get the trial and everything, but यहाँ पे there is, because you don't really know, right, कि कब उसने तो किया नहीं है वैसे, but you don't know कब करेगा and all of that. Okay. So there are some safeguards for punitive detention and for preventive detention. So we will see. So safeguards for punitive detention means it is available to all arrested persons except enemy aliens. Okay, foreigners ko hai, but if you are an enemy alien then you can't have these rights, and those under preventive detention. Okay. So kya kya hai safeguards? The right to be informed of the reason for arrest, right to consult and be defended by a legal practitioner of choice. Okay, right to be produced before a magistrate within 24 hours, excluding traveling time, and no detention beyond 24 hours without the magistrate's permission. So you have all of these safeguards. Correct. What about preventive detention? So preventive detention is allowed under Article 22, Clause 3 through 7, but with strict conditions. Okay. If detention is greater than 3 months, it requires a review by an advisory board, which includes a high court judge. Okay. Detention can continue only if the board approves for further detention. And grounds of detention must be communicated to the detainee as soon as possible. Okay, यहाँ पे it is the right to be informed, but here it should be informed as soon as possible, but that time limit and all has not been placed. Okay, the detainee must be given an opportunity to represent against the detention. This is the same thing. This is for regular arrest. Punitive detention, clause 1 and 2. Must be informed for the reason of arrest and right to consult lawyer. Okay, 2 talks about produced before the magistrate within 24 hours. Okay, and it says that 1 and 2 does not. Article 22 clause 3 says that the above rules do not apply to enemy aliens and preventive detention cases. So this is for the preventive detention cases which we saw. Now the parliament and the state legislative assemblies concurrently make laws on preventive detention. You have to tell me prisons comes under which list under the 7th schedule. Okay, homework for you. Now the right against exploitation, articles 23 and 24. So this right seeks to protect human dignity by prohibiting all forms of forced labor, human trafficking and child exploitation. Okay, so first we will see the article 23. Prohibition of trafficking and forced labor. Two objectives to uphold human dignity by banning exploitative practices that treat people as commodities or instruments of labor. So what are the key provisions? It prohibits human trafficking, begar, which is a forced labor, bandhua mazdoor, forced labor, ठीक है, and other similar forms of forced labor and exploitation. It applies to both citizens and non-citizens and protects individuals against both state and private persons, again just like Article 17. Okay, however there are some exceptions. The state can impose compulsory service for public purposes, example military service, disaster relief, or social service. But such service must not discriminate on grounds of religion, race, caste, or classes. Okay. So, what is the legal backing for Article 23? Enforced through laws like the Bonded Labor System Abolition Act of 1976 and Immoral Traffic Prevention Act of 1956. Okay. Now, this article is for child labor, Article 24, to protect children from physical and mental exploitation by banning hazardous child labor. So, what are its key provisions? It prohibits the employment of children below 14 years in factories, mines, or any hazardous employment. But there is a scope and limitation. The article applies to both state and private individuals again, and it does not prohibit children from working in non hazardous or family based occupations considered innocent in nature, जैसे helping parents in agriculture. Okay, so it is only for hazardous factories, mines, जैसे hazardous. Okay, but the children can help their parents in agriculture or any family based or any non hazardous working. ओके इसके लिए लीगल बैकिंग क्या है इट वाज एनफोर्स्ड थ्रू द चाइल्ड लेबर प्रोटेक्शन एंड रेगुलेशन एक्ट ऑफ 1986 which was amended in 2006 which prohibits all employment of children under 14 in any occupation with limited exceptions and bans hazardous work for adolescents also. So 14 to 18 years tak bhi it is banned now. Okay, then we have the right to freedom of religion, Article 25 to 28. Okay, so this forms are basis of secularism, correct? Article 25, freedom of conscience and free profession, practice and propagation of religion. So this is individual centric, to uphold the individual's freedom of belief, religious expression in a secular state. Okay, this grants all persons the right to freedom of conscience, as in the inner freedom to believe in any religion or no religion also. Right to profess, openly declare one's faith. Right to practice, okay, perform religious rituals and customs. Right to propagate, explain and spread one's religion. Okay, but there are some limitations. This is the scope is that it is available to both citizens and non-citizens, and it is subject to public order, morality, and health. See, we talked about the right to propagate, right? So, the right to propagate does not include the right to forcibly convert another person. Okay, so this is the verbatim of the Article 15. So, Article 15, Clause 1 talks about the subject, subject to public order, morality, and health to other provisions of this part. All persons are equally entitled the freedom of conscience and the right to freely profess, practice, and propagate religion. Okay, then state can make laws. Article 25 clause 2 talks about the limitations. It can regulate secular activities tied to the religion, जैसे finances. Okay, economical, financial, political, or other secular activities tied to the religion, that can be done. Okay, and it can provide for social welfare and reform or throwing open of Hindu religious institutions of public character to all classes and sections of Hindus. So it also promotes a social reforms and allow all Hindus to access public temples. So this can be done by the government. This is given in the constitution itself. Okay. Now we have the Article 26, which is the freedom to manage religious affairs, and this is a group centric right. Earlier was the individual centric right. Okay, so this is to ensure that religious denominations or sects have autonomy in managing their religious institutions and affairs. So, what are the key rights under Article 26? It is subject to public order, morality, and health, and every religious denomination or section thereof has the right to establish and maintain institutions for religious and charitable purposes, manage its own religious affairs, internal rituals, customs, governance, ye sub, own and acquire movable and immovable property, and administer such property but in accordance with the law. So, what is the scope? This right is available to religious groups and not individuals. Very important. And denominations must have a common faith, name, organization. Example, the Ramakrishna Mission. Okay, so everywhere they have the same name, they have the same faith, and the organization is same everywhere. So only that can be called as a denomination. Okay, for them to avail this right. Then we have the Article 27, which talks about the freedom from taxation for promotion of a religion. Okay, so to uphold secularism by preventing the use of public funds for religious promotion. So, what are the key provisions? No person can be forced to pay any tax whose proceeds are used to promote or maintain any particular religion or religious denomination. Okay, so no person will be forced to pay tax जिसके proceeds can be used to maintain or to promote just one some particular religion. Okay, the state cannot use taxpayer money for funding religious activities or institutions and ensures a separation of state and religion in the financial matters. ठीक है, but exception is there. Fee versus tax. The state can charge a fee for services for regulating religious endowment. Okay, ये कर सकता है, but it cannot impose taxes for that because taxes are compulsory contribution for the public purpose. Okay, and it cannot be used for religious promotion, but fee can be taken, and for that particular service fees can be taken but not tax. Now, Article 28, freedom from religious instructions in state funded institutions. Okay, to maintain a secular character. So, what are the key provisions? No religious instruction shall be imparted in educational institutions wholly funded by the state. So, it ensures that students are not forced to receive religious education in fully state funded schools, and it balances secularism with respect for pre existing religious endowments. And no student in a state recognized or state aided school can be forced to attend religious classes or worship unless they or their guardian, if a minor, give consent. However, there is an exception again. This restriction does not apply to institutions that are administered by the state but are established under a trust or endowment which specifically requires religious teaching. ठीक है, if the institution has been established under a trust or endowment which is a religious which requires religious teaching, then you cannot say कि the restriction applies here. The restriction does not apply here. Then we have the cultural and educational rights. So Article 29 and 30 protect the rights of minorities to protect their language, script, culture, and establish and manage their own educational institutions. So Article 29 is to safeguard the cultural identity and educational access of groups with distinct language, script, or culture. So it has cultural rights. Clause 1. Any section of citizens, not just minorities, with a distinct language, script, or culture has the right to conserve it. So this applies to both minorities and majorities. Okay. And educational access. No citizen can be denied admission to a state-run or state-aided educational institution on the basis of religion, race, caste, or language. Okay, so there is equality here. It is open for all. Okay. Article 30, educational rights of minorities, to protect the educational and cultural autonomy of minorities in India. So what are the key provisions? Right to establish and administer institutions. So religious or linguistic minorities have the right to establish and run educational institutions of their choice. So this right is exclusive to the minorities, whereas we saw here that this applies to both minorities and majorities. Okay. And this also has a protection during property acquisition. In case of compulsory acquisition of the property of a minority institution, the compensation must not restrict their rights to manage and run the institution. So this was inserted by the 44th Constitutional Amendment Act of 1978. Now, is the minority, this term, has it been defined in the Constitution? No. Okay. Its interpretation is based on language or religion and determined state-wise. Okay, so you have a state-wise minority list. It is not in the Constitution. Now we study the exceptions to fundamental rights. Okay, before that, right to property, Article 31, which is now Article 300A. It was originally a fundamental right under Article 19(1)(f) and Article 31. 44th Constitutional Amendment Act of 1978 deleted Article 19(1)(f) and shifted the property protection clause to Article 300A. So, now the right to property is a constitutional or legal right and not a fundamental right. Okay, so who is it available for? Just citizens or person? This is a question for you. Okay, now since it is not a fundamental right, so there is no direct access to the Supreme Court under Article 32 for property disputes. Okay, so what are the exceptions? Articles 31A, 31B, and 31C are exceptions to fundamental rights. Okay, so 31A, saving of laws for land and economic reforms. So this protects laws related to agrarian reforms, abolition of zamindari, and acquisition of estates by the state. So it basically permits the state to acquire private property for public purposes. Okay, जैसे land distribution, redistribution. Okay, so this is for land and economic reforms. Article 39B is for the 9th schedule protection. This validates laws placed on the 9th schedule even if they violate fundamental rights. So we know that the laws cannot violate fundamental rights, correct? So what the first amendment did was it added a 9th schedule. Okay, imagine a 9th schedule as a box. So whatever laws that are not in tandem with the fundamental rights were to be inconsistent, correct? But these laws were placed in the 9th schedule in this box. And as soon as they are placed in this 9th schedule, okay, they are validated even if they violate fundamental rights. Okay. But IR Coelho versus State of Tamil Nadu struck down the blanket immunity. Okay. And any law placed in the 9th schedule after this date, 24th April 1973, is open to judicial review if it violates the basic structure. Why is this important? Because Keswananda Bharti case. Okay. So IR Coelho was the judgment. Okay. So before this, okay, they have the immunity. But after this date, any law that has been placed in the 9th schedule is open to judicial review if it violates the basic structure. Okay. Now Article 31C, which is saving of laws implementing certain DPSPs. So protects laws enacted to implement DPSPs under Article 39B and 39C, which is equitable distribution of resources and prevention of concentration of wealth. ठीक है. So any laws that are made to enact these DPSPs, even if they are in the violation of fundamental rights, but they are okay. So there were two provisions. Such laws cannot be challenged for violating fundamental rights because they are for the greater good, correct? Okay. And the clause 2 was declaration that a law gives effect to 39B or C cannot be questioned in court. So this was the second provision, but this was struck down. इतना blanket immunity नहीं है. Okay, by the Keswananda Bharati case of 1973. So second provision declared unconstitutional and void, but the first is okay. Such laws cannot be challenged for violating fundamental rights, but they can be challenged if they are violating what? Basic structure. Okay. Then we have the right to constitutional remedies. Article 32 empowers individuals to directly approach the Supreme Court for the enforcement of fundamental rights. Okay. Dr. Babasaheb Ambedkar called this the heart and soul of the Constitution. Okay. So it ensures that the fundamental rights are not just theoretical, but legally enforceable against state action. Okay. They provide a guaranteed legal remedy for the enforcement of fundamental rights by allowing individuals to approach the Supreme Court directly. What do you understand by this? So when we have, yesterday we were talking about an integrated judiciary, correct? Okay. We have some lower level courts, we have high courts, we have Supreme Court. So the road to Supreme Court is via appeals, correct? If you have some case in the lower level court and you are not happy with the judgment, you can appeal to the high court. Okay. Again, that court gives some judgment, you are not happy with that, so you can appeal to the Supreme Court. And Supreme Court is the apex court, correct? It is the highest court of law. So the road to Supreme Court is via appeals. But if your fundamental right has been violated, you can skip all of this and you can directly go to the Supreme Court via the Article 32. Okay. So Article 32 empowers the Supreme Court to issue writs or directions and orders for enforcing fundamental rights. Okay. And Article 32 is exclusive for the enforcement of fundamental rights and not for other legal rights. Okay. So we will see, जैसे we have for Supreme Court we have Article 32, for High Court we have Article 226. Okay. So scope is what? It is only for fundamental rights. Here it can be for fundamental rights or other legal rights also. So this has a wider jurisdiction, this has a narrow jurisdiction. Okay. Territorial reach क्या है Supreme Court का? Of course across the India, and writs will apply only within the territorial jurisdiction of the High Court. ठीक है. Enforceability. Article 32 is itself a fundamental right. So Supreme Court cannot refuse to entertain a writ petition. Very important. But at the same time, Article 226 is not a fundamental right, correct? It is not in the part 3 of the Constitution. So it is discretionary. So High Court may refuse to exercise jurisdiction. Okay. Purpose is to provide a direct remedy for breach of fundamental rights, and it provides a broader remedy for rights violations including fundamental rights and legal rights. Okay. So here it is the mandatory remedy. Supreme Court ka is mandatory remedy and High Court ka is an optional remedy. Okay. So what are the writs? Habeas corpus. It means to have the body. Okay. What is its purpose? To release a person unlawfully detained. And who can it be issued against? It can be issued against public authorities and even private individuals. Who cannot who cannot not be sorry who can it not be issued against? When the detention is lawful, contempt of court or martial court. ठीक है? Then next we have mandamus. Mandamus means we command. To compel public officials, to command public officials to perform their legal duty. ओके किस किस को बोल सकते हैं हम ये? पब्लिक बॉडीज, गवर्नमेंट, डिपार्टमेंट्स, ट्रिब्यूनल्स. किसको नहीं बोल सकते हैं? प्राइवेट इंडिविजुअल्स, प्रेसिडेंट एंड सीजेआई, चीफ जस्टिस ऑफ इंडिया. ओके यू हैव टू लर्न दिस टेबल. बहुत बार क्वेश्चंस पूछे जाते हैं. देन वी हैव प्रोहिबिशन. प्रोहिबिशन मींस टू फॉरबिड, टू stop a lower court or tribunal from acting beyond its power. Okay, you are stopping this. This is preventing something. किसके लिए है ये? Judicial and quasi judicial bodies only. Prohibition is for judicial and quasi judicial bodies only. किसके अगेंस्ट नहीं हो सकता है? Administrative or legislative bodies, private entities. Certiorari means to be certified. To quash an order or transfer a case from lower court or tribunal, ठीक है, to a higher court or tribunal. Okay, so here it was just preventing, this was just stopping. Okay, but this is to stop plus transfer. Okay, a higher court is stopping this. Imagine a higher court is stopping and it is also taking it the issue with itself. Okay, so it is both curative and preventative. तो किसके अगेंस्ट हो सकता है? Judicial, quasi judicial and some administrative bodies as well, but prohibition was only against judicial and quasi judicial bodies. Important. किसके अगेंस्ट नहीं हो सकता है? Purely legislative bodies or private bodies. Quo warranto. By what authority? It is to challenge illegal occupation of a public office. So what authority do you have to sit in that place? किसके अगेंस्ट हो सकता है? Any person holding a public or a statutory office. But private or ministerial post and non-statutory roles cannot be questioned. Okay, very important table. You have to go through, you have to make a note of it, you have to जहाँ पे maybe you study, print it out and paste it in front of you so that you keep looking at it. Okay, final part is armed forces and fundamental rights. So उनके केस में article 33 through article 35 क्या scenes है? So article 3 is restriction of fundamental rights for armed forces. ठीक है, so to ensure discipline and proper discharge of duties in sensitive areas, parliament can restrict or abolish fundamental rights of these people. ठीक है, then restriction of fundamental rights during a martial law. When a martial law is in force in any part or territory of the India, Parliament may indemnify, legally protect individuals in the armed forces or government who take actions to restore the order and provide restrictions on fundamental rights. Okay. But Supreme Court has said that declaration of martial law does not automatically suspend fundamental rights, including the habeas corpus. Article 35 is exclusive power of Parliament to make laws for certain fundamental rights. So Article 35 states that only Parliament and not state legislatures has the power to make laws for giving effect to certain specified fundamental rights, and particularly those requiring uniformity across the country. Okay, and prescribing punishment for act that violate such rights. So ये किसका right है? This is Parliament's right, not state legislatures. Okay, there are some legal rights outside the part 3 of the Constitution. So Article 265, which is regarding the legal right related to taxation. Then Article 300A, legal right to property, which was formerly a fundamental right. And Article 301, which is legal right ensuring economic freedom, and Article 326, which is the right to vote, universal adult franchise. Okay, so this is all about your fundamental rights. Okay, we will do a quick understanding of this part. Okay, so we saw Article 12 and 13. We saw the foundations. क्या थे foundations? State and laws. Correct? 14 to 18, it was equality. 19 to 22, it is freedom. 23 and 24, it was exploitation. 25, sorry about this. 25 and 20 to 28, it was about religion. 29 and 30 is about cultural rights. 32 is remedies. And 33 to 35 is exceptions. Okay, so if you remember this structure, you can eliminate most MCQs. Okay, so that's why this structure is very important. Okay, Article 12, what we talked about? State. क्या है state? Government, legislature, okay, local bodies, PSUs. Okay, Article 13, क्या था उसका basis? Judicial review. Correct. Pre-constitutional laws void to the extent of the inconsistency. Okay, if some part of that pre-constitutional law is inconsistent, that is void. Okay, post-constitutional law is void if it violates the fundamental right. Okay, and constitutional amendments are also subject to the basic structure. Okay, so here it says that the constitution is greater than parliament. Constitution is supreme, parliament is limited by the constitution. Article 14, क्या था? Two concepts: equality before law, negative; equal protection of law, positive. Article 15, no discrimination on religion, race, caste, sex, and place of birth, but reservation is allowed for substantive equality. Article 16, public employment and reservation allowed again. Article 17, untouchability abolished. It is unique because it is also against private citizens, private individuals. Okay. Article 18, no titles. Okay, but military and academic titles are allowed. Article 19, 6 freedoms. This is only for your citizens. क्या क्या है? Speech, assembly, association, movement, residence, and profession. So you can remember this mnemonic: SA MRP. Okay. Then we have criminal safeguards. Article 20. 20 में क्या क्या था? Article 20 में no ex post facto, no double jeopardy, and no self-incrimination. Okay, so past, twice, and self. Remember like this. ठीक है. Article 21. After Maneka, it became broad. So procedure must be just, fair, and reasonable. Okay. Derived rights क्या क्या है इसमें? Privacy, dignity, livelihood, clean environment. So Article 21 is the most widest right. Okay. Article 21, education, compulsory education for 6 to 14 years. Article 22, safeguards against arrest, preventive detention allowed but it is regulated. Okay. 23, no trafficking, no forced labor. 24, no hazardous child labor. Okay, this is against private individuals too. Okay. Article 25, individual freedom. Article 26, group freedom. Both are subject to public morality public order, morality and health. 27, no tax for promoting a particular religion. 28, no religious instruction in fully state funded institution. Okay. 29 is protection of minorities. Minority determined state wise. Okay. And right to establish educational institutions for article 30. Okay. 32, very important, heart and soul of constitution, given by Dr. B.R. Ambedkar. Habeas corpus, mandamus, prohibition, certiorari, quo warranto. Article 32, it is only for fundamental rights. Article 226 is for fundamental rights plus other legal rights. Okay. Exceptions and emergencies. Article 33. Parliament can restrict fundamental rights for armed forces, and martial law does not automatically suspend the fundamental right. Okay. And during emergency, Article 19 can be suspended during the national emergency. Okay. But this is very important, so I'll write it down for you. Article 19 can be suspended I have apparently forgot the spelling of suspended. Okay. During national emergency. Okay. But Article 20 and 21, they remain enforceable. This was given by the 44th Constitutional Amendment, 1978. Okay. So this is all for your fundamental rights. Make sure that you go through this notes, understand via the video, and read your Lakshmikant. Okay. Thank you. Keep studying.